What's the process to determine whether one's an enemy combatant under our law?
Well, I believe that the executive branch makes an assessment of whether or not someone is taking up arms against the United States somewhere in the world related to all of this.
Okay, so it's an executive branch function to determine whether or not this person qualifies as an enemy combatant.
Well, I believe that they make a
under current law.
Under current law, I believe that determination is made by the executive branch, and the person is detained, and then the question becomes whether they are able to bring some sort of legal challenge to that
They have a
determination.
habeas right.
Yes.
Okay, so the law is that the executive branch determines if you're an enemy combatant, and under our law, you can appeal that decision to a federal court through habeas. Is that correct?
I believe that's correct.
Okay. Is it your view that we can hold enemy combatants as long as they're a threat to the United States?
I believe that's what the Supreme Court has determined.
Okay. Did you argue that that should not be the case before in an amicus brief?
I'm trying to think. I had 2 amicus briefs that I worked on, or 3 technically, but 2 different cases.
Well, we'll have another visit tomorrow. So
yes.
Go back and check.
Yes.
I'm pretty sure that in your brief you argued that the executive branch should not have the ability to hold an enemy combatant indefinitely. You need to try them through some process or release them.
Yes, Senator. As you were talking, my clients, the Cato Institute, the Rutherford Institute, and the Constitution Project, made that argument and asked me to draft their brief.
Yes. Well, do you agree with that argument?
Senator, my responsibility was to make my clients' arguments, and as a nominee to the Supreme Court, that's the kind of issue. The Supreme Court did not address that issue. They, in fact, the case became moot.
Did you organize an effort to get 20 judges to file a brief to the Supreme Court on this issue?
Not on that issue, no, Senator.
On another issue?
Yes, Senator.
Okay. Did you actively go out and recruit 20 judges to help you file a brief on another issue regarding law of war detention?
Not technically.
What do you mean by that?
What I mean is that I was at Morrison and Foerster, which was my law firm, in the Supreme Court and Appellate Group. One of the partners at Morrison and Foerster was a former federal judge who wanted to make this argument and who said, I have former federal judges who are friends of mine who would like to join with me to make this argument. So I worked with her, the partner at my firm who was a former federal judge, to make...
So it was her idea to get former judges to write this,
yes.
not yours?
Yes.
And you just helped in the implementation of that idea?
So, Senator, as a member of the Supreme Court and Appellate Group in a law firm, that is the practice.
Right. Now I'm asking
amicus practice, yes.
It wasn't your idea, it was somebody else.
Yes.
Okay. So now, there are people still held at Gitmo today. Do you understand that?
Yes.
Okay. What system is in place regarding their future?
I am not aware of the system right now. I'm not sure exactly what you mean.
Let me tell you what it is.
Yes.
There's a periodic review process made up of an interagency where they go through the files of these folks and they determine whether or not they still present a threat to the United States or the world at large. And I think it's 6 months, maybe a year. But that goes on at least on an annual basis. And if there's a determination that this person still represents a threat to the United States, they're continued to be confined. That's the way the system works. Are you okay with that?
As a policy matter, Senator, I'm not speaking to my views. That's my understanding is that the periodic review system is an executive branch determination of whether or not they're going to continue to hold people that they.
Does that make sense to you as a way to deal with these detainees?
Senator, I'm not in a position to speak to the policy or the discretion of the executive branch regarding how they're going to handle detainees.
The reason I mention it is because in one of the briefs you argued that the executive branch doesn't have that option. That if you had had your way, the executive branch could not do periodic reviews about the danger the detainee presents to the United States. They would have to make a decision of trying them or releasing them. Is that not accurate?
Respectfully, Senator, it was not my argument. I was filing an amicus brief on behalf of clients, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who...
When you sign on to a brief, does it not become your argument?
It does not, Senator. If you are an attorney and you are representing a client in amicus...
Is that your position when you were in private practice? I mean, you sign on to this brief making this argument, but you say it's not your position. I mean, why would you do that if it's not your position? Why would you take a client that has a position like that? Now, this is voluntary. Nobody's making you do this.
Oh, Senator, I would refer you to the same sorts of statements that Chief Justice Roberts made when he came before the committee, which is that lawyers represent clients.
I get that. I'm not holding the client's views against you. The people you represent at Gitmo, they deserve representation. But this is a amicus brief where you and other people try to persuade the court to change policy. The policy I described is a periodic review. If the court had taken the position argued in the brief that you signed upon, we'd have to release these people or try them, and some of them, the evidence we can't disclose because it's classified. You're putting America in an untenable position. This is not the way you fight a war. If you tried to do this in World War II, they'd run you out of town. We hold enemy combatants as long as they're a threat. There's no magic passage of time that you got to let them go. So my question is very simple. Do you support the idea, did you support then the idea that indefinite detention of an enemy combatant is unlawful?
Respectfully, Senator, when you are an attorney and you have clients who come to you, whether they pay or not, you represent their positions before the court.
I'm sure everybody at Gitmo wants out. No, I got that. This is an amicus brief, and I just don't understand what you're saying, quite frankly. I'm not holding it against you because you represented a legal position I disagree with. I mean, that happens all the time. I'm just trying to understand what made you join this cause. And you say somebody hired you, but did you feel okay in adopting that cause? I mean, when you signed on to the brief, were you not advocating that position to the court?
Senator, as a judge now, in order to determine the lawfulness or unlawfulness of any particular issue, I need to receive briefs and information making positions on all sides.
No, I got what a judge is all about. Listen, I'm not asking you to decide the case in front of me right here. I'm asking me to explain a position you took as a lawyer regarding the law of war, and I am beyond confused. I know what you said in your brief. Whether I agree with it or not, it's not the point. I just want you to understand that it's important for all of us to know where you were coming from. If that brief had been accepted by the court, it would be impossible for us to fight this war. Because there's some people going to die in jail in Gitmo and never go to trial for a lot of good reasons, because the evidence against them is so sensitive we can't disclose it to the public. that we're not charging them with a crime. What we're doing is saying that you engaged in hostile activities against the United States, that you are an enemy combatant under our law, and you will never be released as long as you're a danger until the war is over or you're no longer a danger. That's the difference between fighting a crime and a war. Did you ever accuse in one of your habeas petitions the government of acting as war criminals for holding the detainees? That the holding of the detainees by our government, that we were acting as war criminals.
Senator, I don't remember that accusation, but I will say that...
Do you believe that's true, that America was acting as war criminals in holding these detainees?
Senator, the Supreme Court held that the executive branch has the authority to detain people who are designated as enemy combatants for the duration of the hostilities. And what I was doing in the context of the habeas petitions at this very early stage in the process was making allegations to preserve issues on behalf of my clients. A habeas petition is like a complaint that lawyers make allegations.
You know, I've been a lawyer too, but I don't think it's necessary to call the government a war criminal in pursuing charges against a terrorist. I just think that's too far. I don't know why he chose those words. That's just too far. But we are where we are. So let's talk.
Senator from Arkansas.
The Senate will soon vote on the nomination of Judge Ketanji Brown Jackson to be Associate Justice of the Supreme Court. I will vote against her nomination. Judge Jackson may be a fine woman, but she is a dangerous judge. She built her career as a far-left activist, and it didn't change when she put on a robe 10 years ago. She personifies activism from the bench. She has crusaded to undermine criminal sentences, and she cannot be trusted to interpret the law or the Constitution as written. Judge Jackson's record makes clear that her brief stint as a criminal defense attorney wasn't motivated merely by a devotion to equal representation of all. It was part of a deep commitment to leniency for criminals. Indeed, she has continued to act as a de facto lawyer for criminals from behind the bench, as she did from in front of it. Judge Jackson, Republicans on the Judiciary Committee sent a letter asking for details of what happened to justify this new sentence. Judge Jackson refused to provide any further information. So much, I guess, for looking at her record, as she urged us to do. Her leniency isn't limited to child pornographers either. In 2017, Judge Jackson apologized. She apologized to a fentanyl kingpin, his own words, kingpin, because she couldn't find a way to sidestep the law to give him less than the mandatory minimum sentence. She was very sorry that she had to give him such a long sentence. But I guess where there's a will, there's a way. A few years ago, she found a way to re-sentence this self-described kingpin below the mandatory minimum sentence. Through a completely made-up reinterpretation, Judge Jackson made the First Step Act retroactive for this fentanyl kingpin, something Congress had explicitly tried to avoid when it passed the law. This was judicial activism, plain and simple. In her testimony, Judge Jackson claimed that there were no victims in that case. She's wrong. Fentanyl trafficking is not a victimless crime, and anyone who doesn't understand that doesn't belong on the Supreme Court. In another case, Judge Jackson granted compassionate release to a man who brutally murdered a deputy U.S. Marshal on the steps of a church at a funeral. While in prison, this cop killer threatened prison staff and was caught in possession of a dangerous weapon, not exactly a model inmate. He was repeatedly denied parole, yet Judge Jackson granted him compassionate release Because he had high blood pressure. In yet another case, a career criminal assaulted a deputy U.S. Marshal with a deadly weapon while resisting arrest. This was the third time that this criminal had assaulted law enforcement officers, the very officers who risked their life to keep judges like Judge Jackson safe. Judge Jackson didn't just sentence him below the government's request or the sentencing guideline range. She gave the criminal less time than even the criminal himself had advocated. You can't make this stuff up. In 2013, a sex offender who had repeatedly raped his 13-year-old niece was arrested for falsifying sex offender registration records to avoid telling the government where he was living and that he was working at a daycare. The government sought a 2-year prison sentence, but Judge Jackson gave him just 1 year instead. And during that second year, when he would have been in prison, he tried to rape again and then bribed the victim with $2,500 to recant her testimony. This dangerous sex offender was convicted of obstructing justice, yet when presented with a do-over, Judge Jackson sentenced him to just 24 months in prison for those violations. Now, I wish I could say this was to her credit because, to be fair, 24 months was the sentence recommended by the government, but she ensured her order in that sentence would run concurrently with the sentence in local D.C. jail, so he'd only end up serving 1 year instead of 2. Judge Jackson habitually sympathizes with criminals over victims. These are just a few of the many outrageous cases in Judge Jackson's record. The takeaway is crystal clear. If you're a criminal, you'd be lucky to have your case assigned to Judge Jackson. If you're a victim or anyone else seeking justice, you should hope that your case is assigned to literally any other judge. As a trial judge, though, Judge Jackson could only help one criminal at a time. As a Supreme Court justice, she would be able to benefit criminals nationwide in all cases. Judge Jackson's far-left activism extends beyond crime as well. Not only did she engage in what the Sixth Circuit called an end run around Congress to retroactively reduce the sentence of that fentanyl kingpin I mentioned earlier, she also worked to strike down a Trump administration order expediting the removal of illegal aliens on equally specious legal grounds. The law passed by Congress granted the Department of Homeland Security, quote, sole and unreviewable discretion to decide which illegal alien should be subject to expedited removal. Nonetheless, Judge Jackson inserted herself to strike down what she called, quote, a terrible policy by the Department of Homeland Security. Well, I regret to inform Judge Jackson it is not her role in our system to decide whether immigration policy is good, bad, terrible, or any other adjective she wants to use, only whether it is lawful and authorized by law. And of course, the D.C. Circuit Court, which is not exactly a hotbed of conservative jurists, agreed and reversed Judge Jackson's decision, noting that there are, quote, could hardly be a more definitive expression of congressional intent than the language in that law that she disregarded. But Judge Jackson didn't care. She had an anti-Trump op-ed that she wanted to write in the form of a judicial opinion. Judge Jackson has also shown real interest in helping terrorists. Now, it's true that you shouldn't judge a lawyer for being willing to take on an unpopular case, but you can certainly learn something about a lawyer from the cases they seek out. And for Judge Jackson and her friends in the liberal legal profession, these cases were not unpopular at all. Judge Jackson represented 4 terrorists as a public defender, one of whom she continued to represent in private practice, voluntarily. And she voluntarily filed multiple friend of the court briefs on behalf of terrorists while in private practice. To make matters worse, she apparently didn't even bother when she was representing these terrorists. She didn't bother to establish a reasonable belief that what she filed with the court was factually true. 3 of her 4 case filings were identical, word for word, comma for comma. She alleged identical facts and legal arguments in each case. The only differences between the briefs were the names and the case numbers. In every one of those cases, she claimed the terrorist had never had any affiliation with the Taliban or al-Qaeda. And in every one of those cases, she accused the Bush administration and American soldiers of war crimes. And who were these supposed innocent victims of American war crimes who, according to Judge Jackson, had nothing at all to do with terrorism? No siree, nothing at all. Well, one of her clients designed the prototype shoe bomb that was used in an unsuccessful attempt to blow up a passenger airplane. Another planned and executed a rocket attack on U.S. forces in Afghanistan. And a third was arrested in a raid on an al-Qaeda explosives training camp. Yet in every case, she claimed that none of them had anything to do with terrorism. Not a thing. Totally innocent, just goat herders who were picked up by marauding American troops. You know, the last Judge Jackson left the Supreme Court to go to Nuremberg and prosecute the case against the Nazis. This Judge Jackson might have gone there to defend them. Judge Jackson also refused to answer one common sense question after another. For example, when Senator Blackburn asked her what a woman is, she pretended not to know. I asked her who has more of a right to be in the United States, new citizens who followed the rules or illegal aliens whose very first act in the United States was to break our laws. Judge Jackson refused to answer. And when I asked a simple question of Judge Jackson whether releasing Guantanamo Bay terrorists would make us more safe or less safe, she again pretended not to know the answer, even though it's published by the Biden administration. I also asked Judge Jackson if criminals were more or less likely to commit a crime if they knew that they would be caught, convicted, and sentenced. I asked this pretty basic question at least 3 times. It was not a hard question, and yet again, she refused to answer. Judge Jackson also refused to say whether packing the Supreme Court was a bad idea, even though the judge for whom she clerked and seeks to replace Justice Breyer and the late sainted Justice Ruth Bader Ginsburg, neither of whom are known for their conservative views, were both willing to publicly denounce such court-packing schemes by the Democrats. Judge Jackson may feign ignorance, not because she doesn't know these answers, but because liberal judicial philosophy is all too often based on denying reality. As a judge, Judge Jackson has denied that reality again and again. Judge Jackson will coddle criminals and terrorists, and she will twist or ignore the law to reach the result that she wants. That's not what we need in a Supreme Court justice, and that's why I will be voting against her nomination. Madam President, yield the floor.